Hello and welcome everyone to Dorsey and Whitney's webinar, Is Your Company's 401k Plan Next? I'd like to introduce Stephen Lucky, a partner and co-chair of Dorsey's ERISA litigation group. Steve?
Thank you. We hope your company is not the next defendant in the steady stream of class actions challenging 401k fees and investments. And in fact, that it will not see any litigation. Before I introduce today's panel, I'd like to just show you a couple of housekeeping matters on the next slide with CLE credit and related information. And we are welcoming questions during the chat in the chat dialog box. To help us assess the situation that plan sponsors are currently facing, mitigate risk, and pursue winning strategies should litigation come to pass, I'm pleased to introduce our panel today. First of all, we have Lynn Dudley, who is a Senior Vice President, Global Retirement and Compensation Policy of the American Benefits Council, a Washington, D.C. based employee benefits public policy organization comprised of over 440 members of the largest U.S. employers and their service providers. And this is where Lynn helps to advocate before all three branches of government on employee benefits matters. We also have Rhonda Prusak, Senior Vice President and Head of Fiduciary and Employment Practices Liability at Berkshire Hathaway Specialty Insurance, where she develops and brings to market coverages for fiduciary and employment practices liability, including for companies and individuals protecting themselves from 401k litigation. Finally, my partners, Andrew Holly, Kirsten Schubert, and I will share our perspectives and experience defending 401k and other types of ERISA class actions. Before we dive into the current crisis, Andrew, can you provide a thumbnail sketch of how long 401k litigation challenging fees and investments has been with us and what that has entailed?
Sure. And as many of you know, 401k plans are governed by a federal statute known as ERISA. And without going into too much depth, the most important thing about ERISA is that it makes the people who manage a 401k plan, including company executives and those responsible for making decisions about investments and fees, fiduciaries, which means that they have a very high legal standard and very high legal duties that they have to fulfill. And if they fail, they can be personally liable. All of this started back on September 11, 2006, when a plaintiff's personal injury firm down in St. Louis filed a series of lawsuits all on the same day against some of America's biggest companies, alleging that their 401k plans were mismanaged and that the fiduciaries breached their fiduciary duties by doing so. The original complaints were focused on revenue share, a practice by which a mutual fund returns fees, a certain percentage of its fees to plans or to service providers. There were also challenges to the use of mutual funds and just general allegations that the fees were uncompetitive, that the fees charged by 401k plans to 401k plans were uncompetitive and too high. The first round resulted in some significant settlements, but also a lot of losses. And what you saw is you saw theories being developed. You saw legal theories that were unsuccessful being kicked to the side, and theories that were successful being advocated more. You see some statistics there in the slide about the amount of money at issue and the amount of settlements. It's obviously very large. The most interesting thing from the plaintiff's law firm perspective, of course, is that they're entitled normally under the rules of civil procedure to somewhere a contingency fee payment if they're successful. So oftentimes between 25 and 33%. And if you're talking about settlements in the 30, 40, even $10 million, that's a lot of money. And you can see again some statistics there about how much attorney's fees were paid. And oftentimes, very, very rarely did you find very significant per participant recovery. Starting at sometime around 2015 or so, you saw a second wave of litigation. New theories developed. Court decisions were absorbed by the plaintiff's bar, and they learned about how the 401k world works in practice, and they developed their theories. This new round started to focus on smaller employers, frankly, simply because many of the larger employers had already been sued. So suddenly you started to see plans with $1 billion or even less than $1 billion targets. There was a new focus on nonprofits which sponsored 403B plans, and financial institutions that also used affiliated funds. And as well as service provider practices. And again, you see more large settlements and more large attorney fees paid, and over 30 claims settled for lawsuits settled for 8 figures, over $10 million.
Thank you, Andrew. Lynn, there's a new wave of 401k litigation that plan sponsors are facing. What is the employer community seeing? And we can't hear yet.
There we go. There we go. Hi, everybody. I think the optimum word here is wave, because I do think these cases come in waves. You'll see, a rush of cases, and then a period of time where some of the theories, oftentimes similar theories, are being worked out through the courts, and then you'll see conclusion of those cases, and then another wave of cases. But overall, the trend has been very significantly increasing, and it's raising a lot of concerns for plan sponsors. There have been over 170 fee cases just since 2020. You're seeing these cases survive the motion to dismiss just recently, following the Northwestern decision coming out of the Supreme Court, where the Supreme Court made it very clear that the fiduciary has a duty to monitor every investment in the plan. You're seeing cases pick up again, and you're seeing just recently a couple of cases that have survived the pleading stage. In both of those cases, there was revenue sharing involved. Defendants have argued that revenue sharing had value because the money that's returned to the plan reduces administration fees, but the cases are surviving the pleading stage. They're surviving the motions to dismiss, putting a lot of pressure on plan sponsors. They're currently, their cases pending in more than half of the district courts. You're also seeing, and we just talked about this, you're seeing sort of an expansion of the kinds of employers that are being targeted, starting with the large, going to mid-size, kind of bringing down to some of the not-for-profits, and then you're seeing universities, things like that. You're seeing smaller employers target, oftentimes with not that much money, but because they can force settlements, particularly with those small employers, can force settlements very quickly because it costs so much money to defend the cases. And of course, you're seeing a lot of similar arguments comparing where they're alleging different investments are the same or comparable, or even if they're not comparable, to the defendants, that those issues are still surviving that pleading stage. And this is putting a lot of pressure on plan sponsors, Steve.
Perfect. Thank you. Kirsten, broadly speaking, what do these lawsuits look like on the face of the complaint when they arrive at the courthouse?
Well, they are really fun ERISA cases. I'm sure that that's exactly what you want to hear right now. All of our clients love ERISA. We have a couple of different kinds of claims. We oftentimes see breach of fiduciary duty, the duty of prudence, and the duty of loyalty. These are, I think, importantly to keep in mind, brought against not only the plan sponsor and the benefits committee, but the plaintiffs also oftentimes name individual members of the benefits committee. And at many of our clients, those members are senior executives or otherwise pretty high level employees. And so you see a lot of pushback internally from some of these folks who don't really understand why they're named, what they're doing in the case. It's hard because assuming the plaintiffs get past the motion to dismiss, be deposed, have to collect documents, all of those kinds of things. So the general allegations oftentimes include high fees on the funds and then underperformance. Those are kind of the base allegations. The plaintiffs need to allege benchmarks, which they oftentimes do by comparing apples to oranges in a way that the defense bar tries to defend, but courts oftentimes don't dig in enough to really understand that. Some other issues that we see are raising issues relating to record keeping fees, other service providers, the failure to negotiate with those service providers, the failure to do RFPs. Too many service providers, too many record keepers are oftentimes part of the allegations. And I think on the fund array allegations, which we're seeing these days, it's kind of a darned if you do and darned if you don't. You get in trouble for having too many fund options, too few fund options, the use of revenue sharing, even when the results of revenue sharing are lower fees to the participants, plaintiffs can kind of make you look bad. And too many actively managed funds rather than passively managed funds, and then using mutual funds instead of collective investment trusts. So those are just some of the kinds of allegations that we're seeing pop up.
Great, thank you. And then you also noted that there are attorney's fees for plaintiffs when they prevail. Rhonda, is there, and talk a little bit about the insurance that is often available for these types of claims, please.
Yeah, well, as you could imagine, I'm pretty popular these days, and I think all fiduciary insurers are. Now, Andy had talked about the personal liability that's imposed upon planned fiduciaries by ERISA, and that liability attaches even if the breach of fiduciary duty is inadvertent or accidental. There's just no excuse under ERISA, and fiduciaries are required to restore the losses to the plan caused by even their inadvertent breach. And that's really what the fiduciary liability insurance is designed to respond to. So in order to trigger coverage under the policy, a suit has to name an insured as defined under the policy, and generally speaking, directors, officers, and employees are covered under these policies. There's no requirement, generally speaking, to list specific people. Fiduciaries are determined by their function, that's not necessarily by their title. So it's really important to just have broad general coverage. In order to trigger coverage, there also has to be a claim as defined in these policies. And very generally, it's defined as a demand for monetary or non-monetary relief. And there has to be a loss also as defined, which includes defense costs, generally includes the attorney's fees that you're talking about, as long as those attorney's fees are in connection with a covered claim. The settlements, judgments, and certain fines and penalties may be covered under the policies. And further, a wrongful act as defined in the insurance contract has to be alleged as well. And that would be a violation of employee benefit law, which is generally ERISA and similar law anywhere in the world. You want these policies to be broad and global. Lots of companies have subsidiaries all around the world. There are plans that may be subject to ERISA-like laws. There may be non-qualified plans that are covered under these policies that aren't subject to ERISA, but are still subject to state regulations. Further, these policies respond not just to breaches of fiduciary duty, although that's the primary coverage and the purpose of the insurance, but The policies also respond to mistakes in administering the plans, so day-to-day administration of the plans. And then one of the more controversial, I guess, coverages, but one of the more recent ones is acts and omissions in the insured's capacity as settler. So when a company makes a decision, by example, a business decision that impacts a plan, let's say the decision to, I don't know, suspend the 401k matching contribution, which is a business decision that is their right to do, but people are unhappy about it and they sue and they bring some kind of breach of fiduciary duty suit. The defense in that case may be, well, our client was acting in their settler capacity and they were well within their rights to do that. They did nothing wrong. You want to make sure that your policy will help you defend or raise that kind of defense. So that settler wording in the policy is important. Next slide, please.
Notice you put in the next slide some exclusions too. Any key ones to focus on?
Oh, can you go back one slide, please?
Yeah.
Yep. Yeah. So just like any contract, there are certain exclusions. I'll just focus on two of them. The first one, the conduct exclusion, and what that's talking about is the insured gaining any profit or advantage to which they're not entitled, or any deliberate violations of the law. Remember, we cover those inadvertent violations, those accidental violations, and of course, fraud would be excluded. And the other one that causes some confusion is the benefits exclusion. So the policy again is designed to respond to breaches of fiduciary duty, and restoring loss caused by the breach of fiduciary duty. So for instance, in these 401k plans, if excessive fees were charged to the plan allegedly, and there's some kind of settlement that restores some of that money back to the plan, that generally would not be considered a benefit, although there are some courts that have construed that as benefits. But generally speaking, that's very different than, let's say, a medical plan, which would also be covered under the policy, where somebody is denied their medical benefit. If a plan is required to pay a certain benefit, they've promised to pay a specific benefit, and then the plan sponsor says, no, we're not going to pay that benefit, you can't expect the insurer to respond to just this denial of benefit, where the plan participant is actually entitled to the benefit. There's a great moral hazard there. But for these claims that are really not technically benefits, the policy is designed to respond to that.
Well, we'll keep an eye on that. In insurance, Andrew, Lynn had mentioned, and thank you for that. Lynn had mentioned that these motions to dismiss aren't going so well, and the guidance from the Supreme Court that we were hoping for earlier this year didn't quite come. Can you say in a real quick nutshell what's happening on that front?
Sure, yes. And so the federal rules allow you to file what's called a motion to dismiss at the beginning of a case. It is supposed to be a procedural mechanism to separate the good claims from the bad claims, the sheep from the goats, if you will. And in theory, it's supposed to be a very important weapon to be used to be able to control frivolous litigation. The standard for that motion is you have to have what's called a plausible claim, and that's in light of the context overall and the basis of the duty in question here. In this case, a fiduciary duty. So what you're trying to allege, what you need to do, what a plaintiff needs to do to have a motion to survive a motion to dismiss, is that have a complaint that alleges that the process used to administer the 401k plan was bad, was deficient in some way, or disloyal. Because ERISA doesn't guarantee success, or fiduciary responsibility doesn't mandate success. It just mandates good process. Now, of course, the plaintiffs don't have access don't often have access to the inner workings of the fiduciary committee. So instead, what they do is they try to allege objective criteria about the plan, which creates an inference of bad fiduciary practice, at least according to the plaintiffs. Now, the trick with these motions is that they're generally based on the allegations in the complaint, which they can, they subject to ethical constraints, or they're fairly free to allege. But you can, and this is critical, you can use critical documents to rebut some of those allegations. You can show that the allegation about the amount of fee is wrong or something like this. It's tricky, and courts, are careful about it. But if you're careful about what you're doing, you can do that in some instances. But it's a narrow rule. Despite these motions being a critical, weapon, they're not faring very well, at least more recently.
And so, Andrew, just so we can, we're going to talk a little bit more about the details of this. In a nutshell, what are the numbers, and what has happened with Hughes?
Yep. So since 2020, there have been at least 52 motions to dismiss that have been denied. Very few have been granted. In fact, following the Supreme Court's decision in Hughes, which is at least perceived to be a plaintiff's win, the Ninth Circuit just reversed two motion to dismiss wins. We'll talk more about what's alleged in those later, but the trend is definitely not uniformly, but definitely working against the defense bar at this point on the early motions to dismiss.
Kirsten, if the defendants don't win their motion to dismiss, or if they're defending one, can you say in about a quick minute what the litigation looks like? We're not hearing you.
Sorry. The litigation is ugly. I mean, you can't count on a full stay of discovery like you might in a securities action. You have to move forward. It's judge specific, it's district specific, and discovery is a big burden on the defendants. The defendants take up most of the expense, most of the time, most of the energy, and then you move into class certification, summary judgment, experts, and eventually trial. It's common to go through some of these steps and see where the facts take you, which may be towards settlement.
And so if the motion to dismiss is a big part of the game, and you mentioned settlement, Kirsten, Andrew, very briefly, what's the settlement front been looking like?
So since 2020, we've seen 40 plus settlements, at least 40 plus settlements in these cases. Many of these settlements are just low 7 figures or even 6 figures. There's been a number that have been 8 figures, and that's with the largely larger plans, or plans that have proprietary or affiliated funds. And even in those instances, as I mentioned before, you rarely see a particularly high recovery per participant. It's usually at most in the hundreds of dollars per participant at best. And I think that, as Kirsten mentioned, the pressure and difficulty of litigation and the cost puts an enormous pressure on fiduciaries and defendants to settle the case. It is burdensome. There is risk. Discovery is hard. You are affecting your senior executives' lives and giving them stress and anxiety. And so you see settlements that have very, very little to do with necessarily the merits of the case. You have plans that are very well run, very appropriately run, that you would ultimately be successful at trial. However, the cost and burden of settlement is difficult. And we saw this interesting soliloquy in the Supreme Court's oral argument in the Hughes case, where you saw Justices Kavanaugh and Alito talking with the Solicitor General about, in theory, motions to dismiss are supposed to be useful, and if not, then they're going to win. And then trial will sort everything out. But the practical reality is that it's very, very rare to have trials, and the pressure of settlement is such that once you get past the motion to dismiss, the pressure of settlement is extremely high.
Thank you. And I'm familiar with that colloquy at the Supreme Court. And I think one of the justices was even asking the Department of Labor about the effect of these lawsuits, and they're going beyond the motion to dismiss on the fiduciary insurance market. And Ron, what are you seeing in the effect on fiduciary insurance from these lawsuits?
Yeah, and it was surprising to hear this fairly extensive discussion of fiduciary liability insurance by the Supreme Court. It, just several years ago, the fiduciary liability I once described in an article as a sleepy backwater. So, but it's not so sleepy anymore. So needless to say, we insurance underwriters are doing a lot more underwriting and asking a lot more questions. And later on in the presentation, if we have time, I'll walk you through some of those typical questions. But also insurers are tightening terms, because many of them, especially the insurers that have been around a long time and have some of those legacy older claims, that part of that original wave of claims that in many cases had large 8-figure settlements and similar numbers on defense expenses. Insurers are reducing capacity, whereas several years ago, it would be common for an insurer to deploy 20 or 25 million in limits or even more. Now it's much more common for each insurer to only put up 5 or 10 million in policy limits, which doesn't mean that there's not less capacity available. It just means that the insurance broker, the intermediary between the insurer and the insured, has to work a little harder to find that capacity. So generally speaking, the larger the plans are, the more insurance is purchased, and towers of insurance in different layers are built. So let's say if someone buys 50 million in capacity, whereas before you might get 2 carriers to deploy 25 million each, now it would be 5 layers of 10. So capacity is out there. It's just more insurers typically have to get involved. What you're seeing most commonly are higher retentions or deductibles. So insurers really are trying to really protect themselves, and limit their exposure, but also make sure that the client has some skin in the game with this, and just to ensure that their books, that the insurers are profitable, remain profitable, but you're also seeing other tightening of terms like separate retentions applied for fees, separate retentions for mass or class actions. That's a pretty broad exclusion and would not just be limited to these quote unquote fee cases, proprietary fund cases. You might see outright exclusions on related to plans that hold these plan sponsors' own proprietary investments. And of course, higher premium. There was quite a bit of discussion of higher premiums getting so high on fiduciary liability insurance. It's not quite accurate. You're seeing more of these tightening of terms, but not as much substantial increasing of premium.
Question: if the retentions suddenly are a million or even or several $1 million, then that motion to dismiss and initial discovery that Kirsten was talking about is now going to be paid for by the insured, probably, right?
Or at least a good part of it, yes.
Yeah. Lynn, what are the employers? How are the employers community responding to the tightening markets and the onslaught, so to speak?
Steve, that's a great question. I think plan sponsors continue to make the case, hey, look, these plans are voluntary. But the truth of the matter is a lot of companies don't feel like it's not just an easy thing to walk away from your plan. I think courts have recognized to some degree that it is a voluntary system, and you don't want to, as noted in Dudenhofer, you don't want to constrain it so much that there's no incentive to have a plan. At the same time, I think that argument that the plan system is voluntary doesn't carry quite as much weight as it used to. And I think companies are responding to that by looking at alternatives like pooled employer plans, where they can offload some of the risk of fiduciary responsibility, hiring fiduciary experts to assist them, that sort of thing. I think at the same time, they're concerned about the increased premiums. I think it has a direct impact on their benefits spend. Many employers pay administrative fees, or at least partially pay them. This is putting pressure on that ability to pay those fees, 20 to 40%, we note here in the slides, but over 2/3 also provide a matching contribution. I think it puts pressure on how much, whether they become more generous. I think it puts pressure on other benefits. Look at the increased healthcare costs that employers have had to bear. The idea that these benefits are in a silo is wrong. They're looking at their whole benefit spend. I think it's, also you're going to see employers, you've already seen it, reduce the number of investment choices, streamline the investment choices, don't do anything out of the ordinary, less innovation. And I think employers also genuinely are concerned about their brand, about the morale of their employees, about what they see in social media. And they genuinely don't want to see their company hurt by these suits. So they have a tendency to look for a least expensive option, which might be streamline the plan, reduce innovation, and settle the case.
There's a question, and you're in regulatory and legislative circles. Is there any discussion about safe harbor parameters potentially for these plans from a regulatory or legislative standpoint?
I love that question when I saw it pop up. I would love to see that happen, but there is really not right now. And despite my best efforts, council has written letters, we've highlighted, we've sought legislative relief around these issues to create fiduciary safe harbors, to require adherence to pleading standards. But there really hasn't been a focus on that. It's not, one administration versus another. It's just in general, regulators and legislators have not jumped into that fray to try to solve the problem that way.
Well, I guess we'll have to solve the problem ourselves. And so at the next slide, what I want to pivot to a little bit here is, how do we assess risk? How do we mitigate risk? And how do we develop winning strategies? And so, Andrew, let's put ourselves in the plaintiff's class action shoes, firm shoes, very quickly. What are they looking for? There's hundreds and thousands of plans for them to sue. Who's on their radar screen?
Right, and there's a lot of detail on this slide, but I'll just highlight a couple of really, really critical things. As I mentioned before, you're starting to see sort of a streamlined pleadings and allegations, because the theories have become more fleshed out in courts. And what the critical pieces that the plaintiffs are looking at is your regulatory filings, your disclosures to your participants, which have information in them. The two really, really common ones are record keeping fees that are above sort of alleged benchmarks. The 35 basis points has been sort of the standard allegation, and anything above that starts to become a target. Sometimes the plaintiffs are looking at anything over 20. And the other thing that's a really, really huge target is going to be the use of revenue share. The plaintiffs will allege that the revenue share option is more expensive than the institutional class fund, and therefore there's no benefit to that. It's just a more expensive fund that has the exact same characteristics as the less expensive one. And by and large, those allegations have survived the motion to dismiss. Not always, but by and large, they have. Past that, the other objective criteria has to do with the performance of your funds over time, use of affiliated funds, and just the number of funds that you have. Those are the critical things that plaintiffs are looking at today. As I mentioned, those are becoming more and more streamlined and more and more cookie cutter these days.
So, Rhonda, I expect that perhaps addressing the same question from a different angle, how are fiduciary insurers assessing 401k risks that they underwrite?
Well, we're trying to put ourselves in the shoes of the plaintiff's bar. And so we're trying to determine what those fees are. and what the likelihood would be of our client seeing a fee case, as well as what the plaintiff's damages might be under their kind of crazy calculations. And so we asked some very detailed questions. And first of all, since I think it was Andy who mentioned that this is all about, or fiduciary duty is about your process and having a robust and thoughtful process. There's nothing in ERISA that says that you have to, guarantee the performance or have the lowest fees. So the first thing we want to make sure is that our client has a good process. And we want to know how they go about assessing the reasonableness of fees. If they are hit with a fee case, can they be defended? And then all the questions will generally are more pointed and are follow what the plaintiffs are typically looking at. Flat fees, which is what the plaintiff's bar says is appropriate, a flat per participant record keeping fee versus asset-based record keeping fees. Lynn, I believe, mentioned that a number of companies and organizations actually pay the record keeping fees. I think the statistic was something like 20 to 40%. They pay those record keeping fees. That's a great fact to insurers. Is the plan sponsor deriving income from the plan in any way, whether it's through affiliated or proprietary investments or services? Or another red flag for me as an underwriter is the company charging the plan for the costs of their HR professionals? That's something that'll trigger a DOL audit. RFPs, requests for proposals, to see if you can shop your plans, to see if you can get better services. The Department of Labor has suggested that the appropriate time frame for those is 3 to 5 years. So that's something that we look for as well. It's always a bad fact for us if we see that our client has never sought other proposals, has never shopped their plan, has never negotiated fees, or has only recently done it for the first time in 9 or 10 years. That to me is a red flag and increases the likelihood of this litigation, active versus passive management. But very pointedly, we look at the target date funds, which are often the default investment option in the plan and usually the largest investment as a group in any plan. And we know that the plaintiff's bar is specifically focused on target date funds and whether they're actively or passively managed and how they're performing. And the other big issue, the lowest available share class. And then finally, the Department of Labor has actually started focusing on cyber and privacy issues with respect to plans. So certain carriers may ask questions around that. And most carriers are now asking for the 408B fee disclosure statements because there's a lot of specific data that we can get from that we can't get anywhere else.
Well, thank you. Those are all great guideposts for how we can limit exposure and liability. Kirsten, are there any clues for our clients and friends to tell if they're on a class action firm's radar right now? Because every day there's a new class action being filed, it seems.
Yeah, like we've been saying, there are some repeat customer class action firms, and those are getting more sophisticated. But there are some up and comers too. A couple of indications that something may be coming your way is if there is an advertisement or a solicitation on the internet It's not uncommon for plaintiffs' lawyers to be scrounging around looking for potential named plaintiffs just using internet advertisement and solicitations. There is also a good indication that something might be coming your way if you receive some requests for information from plan participants that might seem a little broader or, excuse me, maybe a little targeted. When you get a 104B request, take a really close look. You probably want to vet it with counsel if it asks for some kind of additional information. And then be strategic about the information you decide to produce. Don't overproduce documents. Don't give documents that aren't required. But make sure the information that is required is produced. And when you do that, make sure that it is the most up-to-date version of the documents, that there is not, like an updated fact missing, like, there is, let's say, an investment policy that was developed 10 years ago and has been amended a couple of times. You'll want to produce the amendment rather than the original policy. 5500s can also be used against you in that same vein. We've seen cases where, a 5500 that didn't contain the most updated information was used as the basis for a lawsuit, and it turns out, the actual facts, had they been known at the time, would not have lent themselves to that lawsuit. So you want to be really careful to make sure those are accurate.
Thank you. And sometimes there can be close questions about whether ERISA requires plans to respond to those 104B requests, and it's not always entirely clear whether or not a document is responsive to that, and but also it may be helpful. So I appreciate the idea to be really cautious when you get those. And so realizing, however, that litigation may come despite a company's best efforts to avoid it, let's talk about how a company can respond with a motion to dismiss and potentially start preparing now for that day. Because you will be coordinating with counsel basically on a strategy to prevent the plaintiff from outfoxing the pleading rules with illusions of factual disputes that make it appear that a well-run plan, by maybe just providing half the picture, is not being well run. And so obviously key to all of this is motions to dismiss, reminding the court that it's an important tool for weeding out meritless claims, the plausible sheep from the meritless goats, as the Supreme Court said. And we recommend focusing like a laser beam on the standards of liability, which is that absent evidence of a flawed process, of where the fiduciary was asleep at the switch, absent evidence of that, which the plaintiff really isn't going to have, because they're not going to have a view in towards what's going on in the committee room, is the plaintiff able to allege facts showing something out of the ordinary that's going to raise a plausible inference that the fiduciaries were asleep at the switch? For example, more expensive investments are chosen over cheaper yet identical investments. And a court would look at something like that and say, well, what's going on here? Let's let it go on to discovery, that expensive discovery that Kirsten was talking about. And I think what's really helpful to do is to really appreciate, even though we don't want to get too much into the details of what the litigators do when they get to court, it's important to know the really limited lens that the court has when it's deciding that motion to dismiss, which is going to be, at that point, in many respects, as we've seen, game over if you haven't won that, because then you've got the settlement pressure. And it's going to be those documents that Kirsten was just talking about, those plan documents. And also we'll call them source documents, documents that are embraced by the complaint. And with that narrow lens, what we try to demonstrate is to encourage the court to make a context-sensitive analysis and essentially to show that there's an absence of apples to apples comparisons. In other words, when they're saying, as they did in the minors litigation, that the investment performance was poor compared to benchmarks. How do we look at that? What documents can we show to say, well, wait a minute, they're comparing apples to oranges, more equities laden investments with more fixed income laden investments. Or in the recent Mador case in Pennsylvania, the court actually said, we're going to require comparisons between Honeycrisp and Granny Smith apples. And the court acknowledged, in the context of record keeping fees, that might be pushing it a little bit, but it does show really what the focus needs to be at the motion to dismiss stage on how we are walking the court through the standard and through the limited documents that it's able to see, to say, you can't look at the fact that there's revenue share and conclude that means there's a flawed process. You can't look at the fact that this isn't the cheapest investment option, because the Department of Labor says you don't have to have the cheapest. In other words, to keep that court focused on the standard, focused on the documents that you're able to use, and to show that the plaintiff hasn't gone beyond showing that it's not enough to show that a fiduciary violation is possible. You have to show that it's plausible. And one of the silver linings that came out of the Hughes decision that somewhat disappointed the bar in general is that it did point out that fiduciaries face difficult trade-offs, and that has to be taken into consideration, and that it really forms a basis for saying that you would really have to allege that there was an abuse of discretion here. And so focusing on all of these factors, avoiding collateral issues, I would encourage, to make sure that the court doesn't lose the thread and that the issue doesn't devolve, that we're focused on, does this suggest a flawed process, as opposed to, do we have facts that both parties disagree on that would devolve into a need for discovery? And I would suggest, because the ratio of wins to losses is awfully poor for the defense, we just have to engage the court in a very candid way to say that these are some of the exceptions in terms of how there's a few courts out there that have done a really nice job of keeping the thread and looking at those documents that they're allowed to look at and say, we haven't fled it. And those are identified on the next slide, which you can look at your leisure, but I did sort of cover them. And Lynn and then Rhonda, if you could just, quickly address, is there, as these cases are winding through the courts, can the employer community, can the fiduciary community and insurance community weigh in a little bit to let the court know what's going on?
Rhonda, why don't you start? Oh, you want me to start? Okay.
Oh, no, go ahead. Start, yeah. However you want to do it.
Well, let me just throw in a couple of thoughts, and then Rhonda, you take it away. I think that we're very committed. I think the employer community is very committed to weighing in on the fee litigation lawsuits. I think that they do play a very important role. I think sometimes it's very challenging to get the court to take a look at the amicus brief, particularly if the court senses that the brief is trying to take the defendant's side without offering something additional beyond the arguments that the defendant is making in the case. And so I think for us, amicus briefs, and the council files a lot of them, I think what we try to do is provide information to the court that they wouldn't otherwise be getting in the argument, something additional that helps them understand the policy behind ERISA, the policy behind the voluntary system, why pleading standards need to be adhered to, what the impact of the litigation is on the plan sponsor system and on people in general. Because one point that I'm always making in the amicus briefs is that, lawsuits don't just automatically benefit everybody in the plan. Think about all the people that come after that group that succeeds, that might succeed or get a windfall. there's a whole lot of people that are retirees or future participants in the plan that are affected by lawsuits. So I think helping the court understand that is really important. Rhonda, you want to add to that?
Yeah, so in terms of persuading the court, and insurers really have to tread carefully, because whatever we might put out there could sound a little self-serving. But I think where we can be persuasive and help sort of guide our clients is with these questions that we're asking and with these issues that we're raising. Our clients are learning that these are important issues, and that I've been doing this for a very, very, very long time, and I've probably examined thousands, literally thousands of plans, and frankly, what I've seen is a huge improvement in practices over time, and it really is a shame that just because the litigation is so expensive that our clients don't get to have their day in court, really, because many of them have a good, if not most of them, have a really good story to tell. But so I am cautiously optimistic that more and more of our clients will prevail ultimately, but they are becoming better and better and better educated plan fiduciaries.
Thank you. I want to just respond to one question that came in. Is this a jury trial or a court trial? And it is a court trial. And I think that gives us a little bit of additional bandwidth in terms of being able to explain complicated concepts to the court in explaining why there isn't a breach of fiduciary duty or one hasn't been pled. But I also, in mindful of all of these comments, and knowing that this motion to dismiss could be coming for any one of us at any time, in terms of what we can be doing now, are there ways, Andrew, that we can be attentive to the evidence that is going to be that the court is going to view through that very narrow lens on a motion to dismiss? That the plaintiffs, frankly, are going to be looking at to tell whether or not they should even file this lawsuit, because they're looking at the same thing. They don't want to try this case. They want to get past the motion to dismiss. Are there things that we can be looking at? And I'll just say one other question was that we received was, what if 100% of the revenue share is going to the plan or to the participants? Weave that into your answer.
Yeah, so excuse me. Once upon a time, people saw ERISA regulatory filings as something that was a regulatory matter, it satisfied the DOL, check the box, and be done with it. And more, we have to realize that the regulatory filings and the plan documents and communications that we provide, that are provided to participant, need to be viewed through the lens of litigation. This is how plaintiffs, there's two things that they do. Plaintiffs use these documents to determine whether or not to sue you, but also these are the documents that can be, that you can hopefully use on a motion to dismiss in narrow circumstances, should that unfortunate event happen. And I think so you have to look at these documents less as just regulatory obligations and more as preparing for that litigation to avoid it. Just because we've seen we've seen several cases that we know of and we've handled where lawsuits have been filed exclusively, very likely exclusively, because of errors in that process, and they wouldn't have happened had there not been errors. And so one of the things, so you have to realize that you have to assume that plaintiffs are looking at your 5500s to understand the fees that you're charged, and are they above benchmark? And obviously you have to comply with the rules and such, but is there a way to, are you characterizing it in the most appropriate and best way, in a way that would limit your litigation obligations or risks? And also you want to have your plan documents and your other documents ready for a motion to dismiss. To give just the most basic example, as we've talked about throughout here, one of the problems that that people run into is allegations about record keeping fees. And the plaintiffs very, very commonly will say, hey, you picked a mutual fund that had revenue share, and that's a higher cost fund than the institutional class share. There's no justification for having a more expensive share class. And so why would you do this? It's imprudent. And a lot of times courts have adopted that. So what if, however, you have built into your contract or built into your SPD or built into the plan document or some other document that you can use on your motion to dismiss, that every penny of that record keeping fee is going to be used to defray plan costs, as it generally should be. Well, then suddenly you have a weapon to go to the court and say, hey, court, I understand that they've alleged that these record keeping fees are high, or the fees for this share class are higher than the other one, but here's what we do with it. And if the court, it's not always a guarantee of success, of course, because there's technicalities about when those documents can be used, can't be used, but it gives you a chance. And there's other opportunities out there that would be similarly successful. Unfortunately, a lot of the documentation about your great process, all the things you're doing to make sure that that things are put together well and that investments are prudent, won't be usable on a motion to dismiss. Be able to use it later in the case, but we've talked about there's a real pressure to settle, and that becomes challenging. And it's very frustrating for clients because they just have to accept these inaccurate allegations, and if they don't have good documentation, it's very hard to rebut. And the last thing I'll just say very quickly is to make sure that you keep your plan documents up to date with your current practices, but also current case law, because it changes very quickly.
Thanks, Andrew. And focusing on the need to keep the court, focused on the proper lens and the documents that are in front of it, is the few cases that have survived, that have prevailed on the motion to dismiss. There's a really nice record of getting in the documents that are just the sort of things that Andrew was talking about. Kirsten, in less than 30 seconds, let's say your documents are not, you don't have that service agreement or the other documents don't reflect that the revenue share is being used in a way that you want. Do you just buffalo through the motion to dismiss, or do you resign yourself to trial, or is there an option in between?
Well, there's definitely an option in between, and I think that it is part of the strategic conversations you should be having. But one option is basically to do limited discovery at the very beginning of the case that might give you the opportunity to get your key documents out there and then, move for an early dispositive motion and in the alternative to a motion to dismiss. I'm seeing in the chat that there's some questions about the materials. Those are coming to you. We will get those fixed. And that's what I have for you on that.
And of course, if even that early dispositive motion doesn't prevail, we've talked a little bit about game over, and it's not game over, especially if the settlement demand is unreasonable. There's a lot of us that are used to litigating cases the old-fashioned way, and that obviously involves some really deep litigation skills, working with experts, defeating the class. Let's not make this asymmetrical or discovery where there's different ways to make the plaintiff have some skin in the game too. There's a lot of things that can be done effectively if you can't win that motion to dismiss, and obviously we all have to do them. But we wanted to focus today on this new, as Lynn called them, the wave of lawsuits that right now are creating a little bit of a dent in the employer community and ability to sponsor these plans. And I really appreciate Lynn and Rhonda and Andrew and Kirsten, your perspectives just in terms of how do we identify this problem, how do we mitigate risk, and how do we work our way out of it. And if other people have questions, I certainly encourage you to contact us, and we're happy to discuss the issue with you further. But thank you very much for participating in the webinar today.